Attention everyone, we are from Group 1 and we will bring the DUZGIT integrity case. Please let us introduce ourselves. My name is Enriliasya Azka H as a registrar.
My name is Nuriz Usaifanny as an expert.
My name is Dinda Rahmatussabana L as a co-counsel of Tomé.
My name is Devisya Sudiono as an agent of Tomé.
My name is Nailah Artanti as a Dewi. My name is Feodora Angelica S as Arbitration.
My name is Dewi Kusuma Maulida as Arbitration.
My name is Tsania Zein as a counsel Malta.
My name is Feodora Angelica S as a counsel Malta.
And we will begin the court session. The arbitration for the DUZGIT integrity case. The arbitral proceeding between the Republic of Malta and the Democratic Republic of Sao Tomé and Príncipe is now in session. His Excellency Professor Alfred Cris, Professor Sudiono, and Judge James Kateka are entering the courtroom. All of the court, please stand up.
The tribunal has conference today to hear the oral arguments regarding the merits of this dispute. We have truly reviewed the memorials from both parties. We will start with the applicant, delegation of Malta.
The tribunal invites counsel from the Republic of Malta to approach and listen to the applicant's submission.
Thank you, Mr. Arbiter and the members of the tribunal who represent the Republic of Malta. This case is not merely about the simple arrest of a financial officer. It's a textbook example of a gross abuse of power by a postal state. On March 15, 2013, our vessel, the DUZGIT integrity, was brutally boarded and sighted by the Sao Tomé Coast Guard while attempting a routine ship-to-ship transfer of fuel.
To Honorable member of the tribunal, the district integrity possibly brutally escaped the transfer of 12 with Maulida vessel carted by the Paris and Condor. There was absolutely no intent to impose cooling in the Sao Tomé, no commercial transaction, and no threat to its territorial security. It was merely under operational stop before hitting the last town for dry docking. Jet authorities created our crew as a side smuggler from the very port encounter in the council. You called a routine transfer and a standard stop. You mentioned that AIS was on. Doesn't the evidence clearly show that your vessel slipped into Sao Tomé's metropolitan waters, crossed the baseline, and dropped anchor without any prior clearance or even a review call to the port authority? Are you trying to justify an illegal entry under the guise of an operational stop?
Your Honor, Judge Kateka, Malta has never denied that the vessel lacked administrative clearance. We concede that the procedural error occurred is failing to notify the court. We don't claim the right of innocent passage for the transfer itself, because dropping anchor interrupts innocent passage. However, our main argument is about proportionality under international law. The response from Sao Tomé was an amateur law enforcement action. We think it was the extreme overreaction.
If I may add, Your Honor, there was no evidence of collision, no threat to public safety, and no damage to coastal infrastructure. Yet sanctions imposed were among the most sacred imaginable.
And then, the respondent seeks to portray this incident as a grave security threat, but the facts simply don't support such a characterization.
I tend to agree with myself at the point. Counsel, please explain posture to the tribunal just how unreasonable was the penalty imposed by the Sao Tomé authorities.
So telling Your Honor, Professor Travis, following the others, the local faculty executive, a man slammed out of the wagon with a ridiculous fine of 5 million euros. Furthermore, the master was declared in the committee for over 3 months, suspended from his family under the immense political districts. This is not law enforcement. Your Honor, this is not sponsoring extortion disguised as dereliction. We demand the immediate release of all remaining assets and full material compensation. Thank you.
One more question, Counsel.
proposal and contributed to tie the vessel and return the confiscated property.
Thank you for your submission, Malta. Now, we call upon the delegation of Sao Tomé and Príncipe to present their defense and counter-arguments. Counsel, you have the floor.
The tribunal invites counsel from Sao Tomé to approach and present the respondent submission.
Thank you, Jesus. Malta's arguments are heavily misleading and frankly insulting to our sovereignty. The DUZGIT integrity was called red-handed pumping the oil in our sovereign waters as an disciplining stage under Article 49, Paragraph 1 and 2 of UNCLOS. We have the absolute right to enforce our domestic laws to protect our waters. The action of our Coast Guard were necessary action of self-defense against illegal maneuvering. We have the absolute right to enforce our domestic law to address multi-task trivialization of the even as procedural error. We must begin the tribunal that unauthorized leadership transfer of thousands of tons of oil is a highly hazardous operation. They granted primarily six nautical miles of our coast. This is not the highest, this is the heart of our articulate water. The action of our coast guard is necessary as self-defense against illegal trade and potential environmental catastrophe.
When we at council, self-defense for what? The tanker was in armor and commercial in nature. 2 trillion passengers raising the master for 10 months and imposing a €5 million fine to be a strictly necessary measure.
The other proposal, we must look at the context. This Gulf of Tsania is notorious of maritime crime, piracy, and devastating environmental disaster caused by unregulated vessels. When our port authorities detect an unidentified vessel conducting operation in our waters, it was treated as a cybersecurity threat. The crew of the DUZGIT integrity was uncooperative. They ignored the VHF radio heads. They resisted initial inspection. This was an illegal and clandestine operation.
Permission to respond your other proposal says the measure were strictly proportionate to the threat. The Gulf of Zein is notorious for maritime crime and environmental disasters. The crew of the DUZGIT integrity was uncooperative and resisted initial inspection. The severe fines and confiscation we are absolutely necessary as deterrent to stop foreign vessels from treating our Príncipe waters as the target.
Unregulated gas station and issues before this tribunal is not whether Malta's vessel suffered inconvenience. This issue is whether Sao Tomé had the right to import its laws again and unauthorized activities within its water, with something that is criminal.
Exactly. A coastal state cannot simply allow its sovereignty to be trampled upon by foreign operations. Article 49 of UNCLOS clearly protects your rights. Please proceed, Counsel.
Thank you, Your Honor, Judge Hidayah. In conclusion, Sao Tomé acts entirely within its right. We did not violate Article 49, Paragraph 3, and any financial or emotional losses suffered by the vessel and its crew are entirely their own fault for deliberately bypassing our law. And then we ask this tribunal to dismiss Malta's claim entirely.
Thank you, Sao Tomé. The tribunal will now grant both parties an opportunity for a brief rebuttal before we call the expert. Malta, you have 3 minutes.
Thank you, Mr. President. Sao Tomé keep using sensational words like clandestine and security threat. Meanwhile, the cargo was fully documented with bills of lading. The country was conducted in broadcast daylight. Furthermore, Sao Tomé claims the crew was uncooperative. The truth is, the Coast Guard approached aggressively, heavily armed, with a proper communication protocols. They are also arresting the entire crew, confiscating a multi-million-dollar cargo, and treating our vessel like a war criminal, only because an administrative error. This is not true. That's a clear violation. Of course, the master was trying to ensure the safety of the highly flammable transfer process.
Mr. President, our agreement fines confiscating assets worth 10 million of euros for a procedural breach is equivalent to the death penalty for a party violation. It violates every principle of international maritime law. Objection, Mr. President. An unauthorized oil transfer of their vehicle is not a party violation. It's a separate breach of custom and environmental sovereignty, and Malta is deliberately downplaying the risk.
Both points are noted. The tribunal will weigh the gravity of the offense against the severity of the sanction. And the tribunal also not start divergence of views specifically regarding maritime security and operational procedure. Therefore, the tribunal calls our maritime navigation expert to the stand to provide an independent assessment. Register, please follow the expert.
Calling the maritime expert to the tribunal.
Please be seated. Good morning. How are you today? Okay, now you can start your argument.
Okay, I have replied that RIS number 22, the shipload books, the board communication rules, and the policy incident reports. The factual complaint is clear. The DUZGIT integrity maneuvered inside the unsupported baselines of South America. They don't answer approximately 6 nautical miles of the coast. There is no record of the detailed control of the cruising clearance from the coastal state via HHS radio for overseeing the ship-to-ship transfer.
Thank you. Excuse me, Mr. Arbiter. Permission to cross-examine the expert.
Granted, your question is asked.
Okay, expert. We want to ask the first question. Is this not true that the ship-to-ship transfer of oil is a highly common commercial practice in the international waters of West Africa? And then, based on your investigation, did our vessel pose any actual environmental threat or maybe leak any oil during that specific time?
To answer your first question, Council, yes, ship-to-ship transfer is a common commercial practice for fuel efficiency globally. However, it is usually conducted outside territorial waters. To your second question, based on my review of the environmental surface, there was no actual oil spill or marine pollution that occurred during the incident.
The expert, we must look at the context, not just the result. It's legally acceptable for some aggravated regulation to conduct ship oil transport inside another sovereign state jurisdiction without even a simple clearance from the local port authorities. Certainly not cancelled. Under the International Maritime Charter, specifically the IMO regulation and maritime guidelines for ship-to-ship transfer of vessel must record crucial authorities before conducting bunkering operation within national jurisdiction. This is to prevent catastrophic external risk and ensure emergency response mission are on standby. By dropping and so arrested, the DUZGIT integrity bypass this critical safety protocol entirely. Thank you, expert. And would you agree that this reporting requirement exists to protect maritime safety and the marine environment, and that the state cannot effectively fulfill its responsibility if vessel conducts such operational without notification?
This Council notification mechanisms are designed to allow authorities to ask the risk, coordinate maritime traffic, and respond promptly to emergencies. Without such notification, the state's ability to fulfill those responsibilities is significantly undermined.
Expert, one final clarification. Did the DUZGIT integrity accept the armed resist the force court on supporting comments?
No, Your Honor, the AIS data showed reflection remains stationary. The logo indicate confusion and the delay in our reporting letter to the ongoing full transfer, which must not be deemed too dangerous to be transferred, but there was no physical confusion.
Crystal clear. The expert testimony proves that Malta has no excuse for its arrogant behavior. With respect, Judge Erika, an administrative failure to report does not justify a 5 million euro fine and 10 months old presidency. Thank you for your objective testimony, expert.
Thank you, expert. Your testimony is found. The tribunal has heard sufficient arguments and expert testimony for today. You can leave the court. We shall adjourn the proceeding and reconvene tomorrow morning for the closing statement and the delivery of the award. The session is closed.
All rise.
The Arbitral Tribunal for the DUZGIT integrity case is now back in session. His Excellency Professor Alphonsus, Professor Nuriz, and Judge James Kataka are entering the courtroom. All of the court, please stand up.
Thank you, Please be seated. Good morning. Today we will hear the final closing statement from both parties before the tribunal proceeds to deliberate and deliver the final award. I remind both delegations to focus on the legal principles. Malta, DUZGIT.
Thank you, Mr. President. In closing, Malta relies heavily on the precedent set by the International Tribunal for the Law of the Sea in the Enriliasya Azka case and the Fiashan case. In both cases, international tribunals ruled that the confiscation of a vessel that is cargo for custom or administrative violence is excessively punishing and disproportionate. The facts are strikingly similar, Your Honor. For a mere administrative oversight, Sultan imposed the ultimate sanction, total confiscation of the property, and a 10-month imprisonment of our master. This is clearly violates the principle of the reasonableness.
While the prosecution violation of reporting occurred, South Tomé response was draconian. A €5 million fine, the absolute confiscation of our ship and cargo, and the prolonged imprisonment of our master can be justified under any modern interpretation of the law of the sea. We ask this tribunal to rest the justice. We declare South Tomé in violation of Article 49, paragraph 3, and award full compensation to the applicant.
South Tomé, your closing statement.
Members of the tribunal, Malta's violence on the Zein case is fundamentally flawed. The Zein case deals with the boundary the exclusive economic zone. The DUZGIT integrity incident occurred within or accessible deep waters. The legal regime is actually different. Under Article 49 of ANUS, our sovereignty over accessible deep water is absolute, subject only to the right innocent passage, a right Malta admits be forfeited by dropping anchor.
So Thomas simply can be expected to act as a passive base and welfare as commercial activities exploit our territory. Reversing our sanction will set a dangerous message that our sovereignty can be maintained, and for him can be bought with market. The sanction were proportionate to the risk they took. We asked the tribunal to uphold our obligation and dismiss Malta's crime activity.
Thank you to both parties. The tribunal will now take a brief recess within the chamber to finalize our deliberation. Briefly, where do each of you stand on the final verdicts? You will apply the Saiga proportionality less the arbitration.
I remain convinced by Malta's particularity. South Tomé exceeded its sovereign rights, and the difference between easy and actualized waters is massive. The difference factor is personal here. Different domestic law justice is definitely discarded. I agree that human rights and the principle of proportionality expressed in moral rules, seizing and interesting, its cargo and all amenable statements. All word of violence toward it excessively organism. The final alone exceeded the follow of the operation. It violates the core principle of rationality in international law. And the position and we have a consensus on the middle ground is one we recognize the absolute jurisdiction of South Tomé we conduct the excessiveness of the unpersonal measures which has raised this constitution. Yes, Mr. President. Everyone, attention please. Having heard the comprehensive arguments from both parties and the expert, review and consider the testimony of the expert, the tribunal is now prepared to deliver its award. The tribunal finds that South Tomé, as an articulate state, possesses sovereignty and jurisdiction over its articulating water pursuant to Article 49, paragraph 1 and 2 of UNCLOS.
Accordingly, Sao Tome was fully entitled to take enforcement measures, including boarding inspection and the application of its domestic customs to mitigate DUZGIT activity for conducting unauthorized seek-to-seek transfer.
However, on the matter of enforcement measures, the Tribunal finds international law brings its enforcement measures to be reasonable and proportionate. The cumulative effect of the sanction imposed, namely the Poland's 10-month detention of captured visa, the exceeding €5 billion fine, and the total confiscation to the official and its fellow department, were exceeded what was reasonably necessary to secure compliance for its further administration violations.
Therefore, the Tribunal concludes that Sao Tome violated Article 49, Paragraph 3 of UNCLOS, which implicitly requires that the exercise of sovereign right must not be conducted in an abusive or disproportionate manner. The Tribunal hereby orders the immediate release of all mining assets and orders Sao Tome to pay material compensation to Malta for the disproportionate economic and moral damage suffered.
Your Honor, we respect South Laut and agree with this convention. We all respect the tribunal awards. South Tome maintains that its actions were taken in a good faith to protect its maritime jurisdiction and national interests. The measure ignores were necessary and entirely consistent with our sovereign rights under UNCLOS.
Counsel, please. The Tribunal has carefully considered all arguments presented throughout this proceeding. The award pleaded is consistent with applicable principle of international law. The award has not been delivered and constitutes the Tribunal final stating the termination of this dispute.
But Your Honor, that was clearly also.
I understand and appreciate the position. Also, Commissioner is unquestionable. The Tribunal has reached its decision on some careful considerations of outcome. We must respect the finality of these proceedings.
Counsel, please understand. The Tribunal has carefully considered all arguments presented. We understand the position regarding the Tribunal. While Sao Tome's decision is unquestionable, no state is above the boundaries of international law regarding proportionality and fundamental human rights. This is the award has now been read into the report. This constitutes the Tribunal's final binding determination of this dispute, from which there is no appeal. In accordance with the award rendered, this arbitral proceedings are hereby officially closed.
The Arbitral Tribunal has officially concluded this matter. All rise. The members of the tribunal will now leave the courtroom. Thank you all for your attendance. The court session has officially done. Thank you for your attention.